Morning, everybody. Welcome to this episode of Exchange Chambers podcast. It's the 21st of August, 2024. My name is Browne, King's Counsel, a barrister at Exchange Chambers, and this morning I'm with
Fiona Tinsley, Head of Clinical Negligence and Serious Injury and also partner at Browne Solicitors.
We're going to consider a recent case in which I advised and which settled for very substantial damages. We're going to consider the challenges posed by the case, and we'll also look to examine how to manage a client's expectations of what they might recover by way of damages in a high-value personal injuries claim. By way of a very brief introduction, the claimant, who we'll refer to as C, sustained very serious injuries when she was an unrestrained rear seat passenger involved in a head-on collision with a lorry which was travelling at 50 miles an hour. Liability for her injuries was admitted, and at the time of the accident she was approaching her 25th birthday. She was a highly intelligent young woman and held a first-class honours degree.
Thanks, Louis. Tell me a little bit about C before the accident happened in terms of her health and her general sort of life story.
She, as I said, was a highly intelligent lady, first-class honours degree. There was quite a significant premorbid history, a significant history of irritable bowel syndrome, and she also had a fairly significant history of psychological problems. One of the issues that we had to consider during the course of the case, so far as causation was concerned, was the extent to which the accident had caused bowel bladder problems and psychological problems, and how that interrelated to her pre-existing problems.
So bowel and bladder problems. What else was the nature of her injuries? Because I understand that they were quite significant.
Well, they were significant, and I think it's important to say at the outset that this was a case in which there was a battery of expert evidence. We had expert evidence in the following disciplines: neurosurgery, neurology, orthopedic, urology, psychiatry, ophthalmology, and colorectal. So that is an indication as the extent of the wide-ranging nature of the injury she suffered. There was no doubt that she'd suffered a seatbelt type injury to her abdomen. She'd suffered a fracture of the lumbar spine as well as chest trauma. The injuries she sustained were sufficiently significant that she required a laparotomy. She had a ruptured spleen. She had a traumatic perforation of her duodenum, a liver contusion, and an ischemic right colon. She had bilateral pneumothoraxes, and there was a fairly stormy post-operative period. She had an inpatient hospital stay, part of which was an ITU, for 5 weeks. She required spinal fixation. So there were very, very significant injuries suffered, without doubt. She reported what at first sight might have seemed like an unusual constellation of symptoms for which an organic basis was sought. So, for example, she complained of daily incontinence. She complained of severe loss of vision in one eye, which came on very suddenly, but 2 years post-accident. And she claimed that she was falling every day as a result of lower limb weakness. So that's an illustration of the nature and extent of some of the problems she had post-accidents.
And I imagine, well, you will have had to get a significant amount of medical records early on in this case, which would have been ongoing throughout the case, as well as other more historic records in order to consider any of her premorbidities. Tell me, at what stage were you in a position where you could prepare your initial letter of claim in relation to liability, or did you get an early admission on this? You mentioned before that liability was admitted in full.
There was an early admission of liability, which enabled us to secure substantial interim payments for her. She was living with a partner. She, at that time, had no children. She had had a child by the time of the settlement of the claim, which we'll come to, and was due to have another child. So the focus early on was in trying to understand what the injuries were she undoubtedly sustained, what other injuries she complained of, what other symptoms and sequelae she complained of, and the extent to which we needed expert evidence to drill down on causation. And of course, that required her legal team to obtain full access to full records.
So what was your starting point in the first sort of tranche of medical evidence that you got? Where did you start with that?
Well, given the complaints that she had, and as I say, they were lower limb weakness leading to regular falls, blindness in one eye, and significant issues of both bowel and bladder continence, we focused on obtaining expert evidence in those disciplines. Neurology and neurosurgery were key, and identifying really top-class experts we thought was going to be key because of the need to ensure that we'd fully analysed the expert issues in those respective disciplines. So we commissioned that expert evidence as key lead disciplines, with a view to at least forming a view in our own mind as to direction of travel in terms of quantum. But we also recognised that given the history of psychological problems, getting psychiatric evidence would be important, and it would also be important to ensure that we had other relevant evidence. So, for example, orthopaedic, because the orthopaedic injuries were very significant, and we wanted evidence from urology to touch on the bladder incontinence as well as bowel expert evidence to deal with that particular issue.
And did those experts support C's case to the extent that C would have expected, or were there some matters that arose which didn't quite align with her interpretation of the injuries that were all causative of the accident?
Well, understandably, as a non-lawyer and non-doctor, C's view was all of her ongoing problems were accident-related, that the past history, while she recognised there was a past history, was not sufficiently substantial to explain away what she regarded as new symptomology. So that was C's position. There were a number of difficulties with that, challenges for us. So, for example, just to highlight a couple, a review in late 2018, this accident happening just a few weeks earlier, there was no reference to any neurological dysfunction, and the claimant was noted to be doing well. She was discharged from inpatient care. There was no report of urinary dysfunction at that stage either. She was discharged from hospital in early 2019. Absolutely no problems with urinary incontinence at that stage. She was mobilizing and was increasing the distance over which she could walk. She was independent, sitting to standing. She could walk for approximately 30 minutes and was going up and down stairs with one banister. So at the time, so 2.5 months post-accident, she was safe and steady, and she had no equipment or support needs according to a physiotherapy assessment.
Yeah. So she was doing fairly well, but her symptomology declined over time.
It did.
And
yeah, it did.
There could have been some other factors that came into play with that, but ultimately, like you said before, it's about her believing, quite understandably, that everything flowed from this accident, and therefore, and obviously the medical records would support the level of improvement that she was making, up to her time of discharge and beyond, for it to then kind of change course where there came a decline. And it must have been quite a challenge for the legal team and for her, explaining to her in layperson's terms, again with the medical experts who are so important in this, aren't they?
Yeah.
In their role that they play in this, in helping the C understand what's related and what's not. But it really, again, you mentioned at the beginning about managing expectations. There is a lot of managing expectations throughout the period of a case, isn't there?
There is.
Because there's so much emotion involved in it, so much physical and often mental injuries that arise from this. And the claimant is trying to find their new normal in the life that they're now leading post-accident. So just tell me about some of the challenges that you had with that and how those were resolved over time.
Well, we never had any doubt about this lady's honesty.
Yeah.
And that's really important.
Yeah.
And I should say that even when surveillance evidence was disclosed, and we anticipated it would be and told the claimant that it would be, none of it was of a nature or extent that caused us to question her credibility. And indeed, it didn't feature to any significant note at the time of settlement. So the starting point was we accepted her as an honest and reliable historian.
Yeah.
And we did not dispute that she genuinely had this battery of symptomology. The question for us was, what is the cause of that? And we scrutinise this really carefully because with the neurology and neurosurgery evidence, because none of the contemporaneous records demonstrated a deficit in either lower limb during the acute admission. As I've said, there was no impairment of bladder function during that acute phase. She was ambulant, was walking. There was no permanent injury to the distal end of the spinal cord. There was no cauda equina syndrome, no injury to the cauda equina nerves in the index accident. And even when she started reporting falls 6 months or so post-accident, imaging of the lumbar spine didn't identify any mechanical problem or the development of a syrinx that would account for those complaints on a physical basis. There had been no urodynamic studies to assess bladder function, and her treating doctors had gone down the road that there was an underlying organic spinal cord injury here. But actually, our experts, the neurologist and the neurosurgical expert opinion evidence, was said there is simply no underlying physical injury. So we had to draw those strands together and explain to the claimant that we needed to search for an explanation that was accident-related, but which did not depend upon a physical injury.
Yeah.
And we were able to do that. And we were able to do it with the help of the neurologist and the neurosurgeon because the conclusion was she had a functional neurological disorder.
And just for the audience's sake, can you just explain what a functional neurological disorder is?
Yeah. It's a condition that I am seeing much more often in personal injury claims. I should start by saying it's a genuine condition.
Yeah.
Now, this isn't a factitious illness. It's a condition which is caused by changes in how the brain network works rather than changes in the structure of the brain itself. So the typical CT scanning, MR scanning of the brain doesn't show underlying organic changes to the brain, but it is a genuine condition and it produces genuine physical symptoms. So it can produce seizure-like problems, it can produce problems with movement, it can produce problems with cognitive function. It's a genuine condition. The claimant in our case was initially reluctant to accept that as an explanation for her ongoing problems. And the reason she gave to us was that, well, people won't think that I'm genuine. People will think that it's made up. I'm making up the blindness in my right eye. I'm making up the problems with my movement. I'm making up the fact that I've got problems with my bowel and my bladder. But we assured her that was not the case.
Yeah.
It was a genuine condition and they were genuine symptoms. And ultimately, the label that we attach is important. It's important for two reasons. It's important because the claimant then understands that there is a diagnosis to explain her condition. And it's important because it's a proper basis for establishing causation.
Yeah. And I imagine, so that was one of the sort of arguments on medical causation that you put forward, and the defendants would have also wanted to explore that diagnosis as well, given the significance of it and given the fact that the claimant initially seemed like she was doing well, but then declined again.
Yeah.
So was there any challenge to that diagnosis on the part of the defendant experts?
Not a significant challenge, but the importance of that diagnosis as opposed to a diagnosis of, for example, a permanent spinal cord injury is that in the case of a functional neurological disorder with high quality neurological rehabilitation,
Yeah.
the prognosis can be good.
Yeah.
With a permanent spinal cord injury, it's not the case.
Yeah.
At least not necessarily the case. And so it did affect the value of the claim, because the defence argument is, well, we accept it's an FND and we'll pay for a high quality rehabilitation in a centre specialising in the treatment of FND, but the prognosis is good.
Yeah.
Can work again, will not need care permanently, will not need single level accommodation. So that's how they factor that into causation and quantum.
And in a way, it's a balancing act, because that's fantastic news for the claimant. She's fairly young. She's at the sort of start of her career. She's probably had moments throughout the case where she's thinking that she'll never be able to do so many different things again, never be able to live her life to the full satisfaction that she would have expected. So it's then that balancing act of the fact that you've got a good prognosis, you're going to pan out all right here, against the backdrop of the evidence that you've got along the way in support of a case which may support those sort of higher valuations of the case. It's the kind of enhancement of your quality of life and your much better quality of life versus the potential compensation that you could have been receiving had this diagnosis not been established and had the prognosis of it not been so good.
And that's a really important point, that, because in advising claimants, I think there are a number of really key things to bear in mind. Claimants in high value personal injury claims, those with capacity or where they don't have capacity, their families, but particularly those with capacity who've not sustained the injuries of the utmost seriousness. We're here to advise.
Yeah.
We're not here to make decisions for claimants. We're here to give them the best advice we can and for them to make decisions. And whilst we know what the purpose of an award of compensation in personal injury claims is about, I often say there's no amount of money that will recover for you that can put you back in the position you were in uninjured, where you've sustained really serious injuries. You must carry on living your life as best you can, because the claim will come to an end at some point, but your life will carry on.
Yeah.
So you must live your life regardless of the claim. Very easy to say, very difficult to achieve, but an important message to deliver, I think.
Yeah. I think it's so important as well for claimants to feel very much in control and centre to this whole process, because it is about them trying to put their life back in some order. It's about them understanding the limitations that they may now be living with, but also the potential for that further rehabilitation, that recovery, which is obviously they'd far rather have that kind of outcome than potentially millions and millions more, and being so severely restricted. And I think that's why it's so important that along the way throughout these cases, as the evidence is unfolding, as the explanations are coming out by the experts, that we, with our own expertise and with our own understanding of medical law, medical records, that we transfer the opinions that these experts are making into layperson's terms. Also to get those experts on board throughout the process where necessary, particularly in conferences where the claimant is present within those, where that whole explanation is playing out, so that because it's about managing expectations all along, it's so important to manage expectations of where the claimant thinks that they're at, but actually, it might not go so much in their favour in terms of the level of compensation that they're going to be awarded, but it's going to go in their favour in terms of the life that they can carry on having.
Yeah, I agree with that. And I think dialogue between all members of the legal team, and actually the experts instructed, is critical. You have to carry your claimant with you, which means they have to understand why you are taking the steps you're taking on their behalf, why you're advising in the way you're advising, and ultimately where you want to end up.
Yeah.
And that requires every single member of the team, claimants included, to pull together to try to achieve that goal.
Yeah. There's a lot of getting your head round these cases for the claimant and for the legal team.
Yeah.
It goes without saying, doesn't it?
It does. And one point I just wanted to make, Fee, also is in that regard, because one of the issues we had really quite a long way through the case, this issue existed, was, well, the claimant was able to point to entries in the medical records which apparently demonstrated an underlying organic cause for her ongoing problems from the treating clinicians, but actually properly understood that those treating clinicians only saw the claimant for a snapshot in time and didn't have the ability to take a step back and to see the wider picture of all of the medical records in the case.
Yeah.
And it's only when you've got the ability to see all of the medical records and to put the chronology into a proper form that the full picture emerges. And when the full picture emerges, that enables the experts in the case to opine on a full basis, but also enables the claimant to see the fuller picture. There's not just a snapshot of seeing Mr. or Mrs. X at any particular clinic. So again, that really illustrates the critical importance of ensuring you've got full, accurate and detailed medical and other records, and a full chronology is prepared.
Yeah. It's like you just said then, a claimant will, at the time they're not a claimant, but C will come into hospital, in a critical way following such a serious accident, and they're obviously triaged, and then they work through various clinicians who are assessing them, treatment plans, investigations, and so on and so forth. And all they can do is get a snapshot and a glimpse of anything that went before that in terms of medical history, social history, even how that person lived before, because obviously there's a great urgency when that person comes in to get them that treatment that they so desperately need. But as you say, it's so important for lawyers on behalf of their clients to make sure that they get all of the medical records, and that full timeline is drawn out of those medical records, so that everybody who's going to become part of this team, experts and so on, and lawyers, etc. And even the reason it's so crucial is because you're going to end up sharing those with the defendant team as well, and potentially a judge one day. And therefore, it's so important to get that core bundle together, not just about the records arising where that person ended up in hospital, but those GP records, any other therapies or treatment that person had in the past, because no one at that time might think that they're relevant, but they may ultimately be extremely relevant, either in helping an expert really assess much more of the bigger picture that without those they just wouldn't be able to consider, because that might be a key piece of evidence that no one thinks to discuss. So it's so important to make sure that all records from anywhere, obviously if they're completely irrelevant, say someone's hurt their foot and nothing's to do with the foot at all, then you wouldn't necessarily get those. But ultimately, there's a great importance on that.
I agree with that. Time spent digesting and analysing medical and other critical records is time well spent.
Yeah, very much.
As is identifying key experts in lead disciplines. And they would be, from my experience of this particular case, they're the two central messages I'd want to put out there. There's no substitute for top-class experts.
There isn't. And I think that's one of the things that we benefit from, the more that we kind of gain our expertise over the years, is that you get together a database of really, really great experts. You also come across some that aren't so great, but you learn from that, and who you also know are so highly respected in the field that you want to make sure that you've got that expert on your team, no one else's team, and that you then know that you've got that expert opinion that's going to really, really help support your case and kind of maximize the value in that, where it's so deserved.
Yeah, I agree. I think that covers all the points I wanted to So,
Yeah.
are there any other points that you wanted to raise?
Yeah, I mean, there's so much more that we can talk about. Obviously, the defendant will have raised various challenges, but they would have got their own expert evidence. In the meantime, you're involved in drafting the schedule of loss, which you're very reliant on the expert evidence that you've collated over time. You know that schedule is going to be subject to challenge, and we've spoken about some of those challenges this morning. Those challenges, they're kind of presented in what we call litigation risk.
Yes.
And again, litigation risk is something that we have to be acutely aware of, and we have to emphasize to our client that they also need to be acutely aware of, because there's always going to be two sides in expert evidence, because it's always based on a range of reasonable opinion, for one, and you've got to consider what's going to come across as more favourable if these cases were ever to go before a judge, and whose evidence they prefer on the day. So that will have been another issue that you've had to deal with throughout this case. Was there anything in particular that the claimant found hard to grasp when it came to, kind of those medical issues, and in relation to where your schedule of loss will start at, but where it will eventually kind of end at in terms of the settlement value?
Well, that's another really good point, because the schedule always represents your very best case, or should always represent your very best case. But hopefully, in schedules that I prepare, it represents a very best case with a confidence evidential foundation. But claimants will look at the bottom, or sometimes look at the bottom line, and think that's the figure that they will recover. So it's important, when going through that schedule with them in draft form before it's disclosed, to emphasize that this is the very best case. That does not mean you'll recover the bottom line figure, because in practicing now for 30 years, I've never had a day where I've recovered 100% of what I did. Maybe some barristers have. I personally haven't. And it's also a significant milestone when you get the counter schedule, because it almost inevitably, in a case like this, the counter schedule will be hard hitting. And in this particular case, it was pleaded on the basis of a positive discount rate.
Yeah.
Of course, at the time we're recording this, there's a negative discount rate, but the anticipation is that will change to a positive rate sometime in the early part of 2025. But we were able to dispose of that in this particular case by indicating we were not entertaining discussions on the basis of a negative discount rate. We had a trial date, and so we were working to that trial date. So absent something exceptional, it was a negative discount rate pursuant to which we were calculating future losses.
So presumably the trial date set because the parties couldn't agree on quantum.
Yeah.
They were so far apart on that, but obviously there's trial or even commencing court proceedings is really a last resort if it can be avoided, because of course alternative dispute resolution is so heavily emphasised these days. In fact, courts won't even accept commencement of proceedings without some evidence that ADR has commenced. So in this particular case, there was an agreement, wasn't there, between the parties that you would try to resolve the issues within the case by way of a joint settlement meeting or JSM?
Yeah, there was. I mean, the trial date was set well in advance because there were so many experts that we needed to accommodate.
Yeah.
And of course, it's critical, in my view, to have a JSM. It is certainly, even in liability, PI, personal injury trials, claims. But there's time to do it. And the time to do it is when you've got all the evidential pieces of the jigsaw in place. And that often means joint statements.
Yeah.
So you've got the expert evidence and you've got the joint statements, and you know where the issues are that are going to be crystallized at trial between experts of like disciplines. So we were not able to do that until quite late in the stage, but sufficiently far in advance of the trial that there was still a real saving to be had by doing it. It is I'm going to go as far as it's a reckless party that doesn't entertain consideration of alternative dispute resolution, whether that's a JSM, whether it's a mediation, whether it's early neutral evaluation at a much earlier stage. In the vast majority of personal injury claims that I deal with, joint settlement meetings either bring about a resolution on the day, or they bring about a resolution of the entire claim shortly afterwards. Not always the case, but overwhelmingly so.
Yeah. And in this particular case, the claimant will have obviously played a pivotal role in that, which would have helped you as her legal team, but would have helped her kind of own understanding of how these things play out. So, first of all, how did you find the claimant throughout the process of the JSM, and also did you settle on the day, or was it beyond that?
She was, by virtue of being a highly intelligent lady, articulate, fully aware of the issues in her claim. She was an active participant in the entire process and was an active participant at the JSM. And that's how, that's what we want. It's not put baby in the corner.
No.
It's essential that you carry the claimant with you and she understands why you're giving the advice you're giving. We settled on the day.
Brilliant.
I'm very pleased to say.
Brilliant. And hopefully she was a very happy claimant on the day.
I hope so.
Yeah. I mean, ultimately, it's very much about balancing your client's emotions throughout this process as well. It's an emotive process throughout, isn't it?
It is.
Right through to the end. Sometimes it can be quite bittersweet, but sometimes it can also have quite a healing effect in that it's come to an end, that person can get on with their life, have an enhanced quality of life because of the significant amount of compensation that you've been able to secure on their behalf, and hopefully the parties walk away happy.
Yeah. Well, and we should never forget that we're privileged to do what we do.
We absolutely are.
And when you're able to see a claim from the outset or near outset and bring it to a conclusion that's a minimum, a fair conclusion, but hopefully a little bit better than that, then that's a very rewarding thing for us to do.
Yeah. No, I absolutely agree. This has been a really interesting topic to discuss, and I'm just so pleased that there was a good outcome for the claimant, and also that she remained or felt that she had that level of control throughout, working with a great legal team by the sounds of it.
Thank you, Fee. Well, on our behalf, can I thank everyone who's listened to this podcast. We hope you've found it helpful. If any issues arise or any questions arise from it, then both Fee and myself are easy to contact by way of email. Please don't hesitate to do so.
Thank you. Thanks a lot.
Thanks. Good morning.